How contract law works. Acceptance. An acceptance must be definite and certain. It must correspond exactly with the terms of the offer. Example: you can have all of my sheep for £500. Okay, I will take half of the sheep for £250.
Not acceptance.
Okay, I will take all of the sheep for £499.99.
Still not acceptance.
Okay, I will take all of the sheep for £500.
Acceptance.
In Tin vs Hoffman and Company, 1873, an offer to sell 1,200 tons of iron was not held to be accepted by a reply from the offeree, stating that they would accept 800 tons instead. If the offeree responds by stating that they accept the offer but on different terms, this is classed as a counteroffer and is not an acceptance. The effect of making a counteroffer is that it destroys the original offer. The leading case on this point is Hyde and Wrench from 1840. The defendant offered to sell his farm for £1,000 to the claimant. The claimant made a counteroffer of £950, but this was rejected. The claimant then tried to accept the defendant's original offer of £1,000, but this too was rejected by the defendant, and the claimant sued for breach of contract. The court held that the original offer could not be accepted. The counteroffer effectively destroyed the original offer. On a comparative law point, the Civil and Commercial Code of Thailand seems to be similar to English law in this area. Section 359 states that an acceptance with additions, restrictions, or other modifications is deemed to be a refusal coupled with a new offer. Acceptance must also be made while the offer is still open. Acceptance must come from the offeree themselves, or somebody authorised to act upon their behalf within the law of agency. A valid acceptance must also be written, oral, or be capable of being implied through conduct, as in Carlisle v Carbolic Smokeball Company. The bottom line is that acceptance must somehow be communicated or inferred through conduct. If, as Lord Denning said in Torres v Miles Far East Corporation from 1955, the words of acceptance are drowned by an aircraft flying overhead or otherwise not heard, there is no contract. It is important to note that in most cases, an offeror can never demand that silence from the offeree be treated as acceptance. In the case of Feldhaus v Bindley, 1862, the statement, "If I hear no more, I will take it that the horse is mine," in a letter regarding the sale of a horse, was held not to create a binding contract. Imagine the sort of absurd results there would be if silence could be stipulated as a means of acceptance by the offeror. I would like to buy your car for £50. If I hear nothing more from you, I will take it that the car is mine. There are 3 exceptions to the rule that acceptance has to be communicated. 1. When the reason that the offeror has not heard the words of acceptance is their own fault, as considered by Lord Denning in Torres and Miles Far East Corporation. 2. Where the terms of the offer expressly stipulate that communication is not required, as in the case of a unilateral contract, such as the one in Carlisle and Carbolic Smokeball. 3. Where acceptance is sent by post. The postal rule can be traced back to the case of Adams and Linsell from 1818. If 1. Post is the expected or a reasonable method of acceptance. 2. The letter has been properly addressed and stamped. 3. The offeree has evidence that the letter was posted, typically in the form of recorded delivery, then they will be able to rely on the postal rule. Under the postal rule, acceptance is taken as having been communicated as soon as it has been posted. There is no need for the offeror to have actually received the letter.
Not postal acceptance. Still not postal acceptance.
With the postal rule, acceptance is communicated upon the actual posting of the acceptance. Here, the actual moment of acceptance has been captured on film for the first time in history.
Postal acceptance.
Should, however, be noted that in the case of Holwell Securities Limited and Hughes, the Court of Appeal stated, obiter dicta, that this rule does not apply if it would lead to a manifest inconvenience and absurdity. Question. If cancellation of acceptance is communicated by the offeree after the acceptance has been posted, is there still a contract? Postal rule does not apply to communication by electronic or instantaneous methods of communication. In these cases, acceptance takes place when and where the message is received. See the case of Entoras and Miles Far East Corporation Limited and Brinkybond Limited versus Staheg Stahl und Stahl and Stahlwaren Handelsgesellschaft MBH, 1983. The Electronic Commerce Regulations 2002 govern online sales, and they state that both offers and acceptance are effective once the person they are directed to has access to them. And now it's time for Rory Mayo's top tips.
Rory Mayo's top tips. Article 19, paragraph 1 seems to concur with the common law position as laid out in Hyde v. Wrench 1840. However, paragraph 2 casts doubt on this position and states that an offer which purports to be an acceptance but contains additional or different terms which do not materially alter the terms of the offer constitutes an acceptance, unless the offeror without undue delay objects orally to the discrepancy or dispatches a notice to that effect. If he does not so object, the terms of the contract are the terms of the offer with the modifications contained in the acceptance.